Tickle versus Giggle. What is it? Who are the parties? What are the issues? Roxy Tickle is a biological male who identifies as a woman. Another way to say this is Roxy Tickle is a trans woman. Tickle wanted to use the female-only app Giggle, which was founded by Sal Grover. There is an issue because Tickle was initially admitted onto the app, so he made it through the AI screening, but was later ejected from the app by Sal manually on the basis of being visually identified as male. Tickle believes that he has a right to use the app as he is legally female. Sal believes that she has a right to offer the service of her app on the basis of sex, so to all and only female people. The background legal issue to this is that when the federal government added gender identity to the Federal Sex Discrimination Act in 2013, they didn't consider the conflicts with sex that adding gender identity might create. In precisely these kinds of cases where a person of the male sex has a gender identity as a woman or as a female, or in the converse case, a person of the female sex has a gender identity as male or as a man. The issue at the heart of Tickle versus Giggle is the conflict between sex and gender identity. The original purpose of the Sex Discrimination Act was to end discrimination against women in the public sphere. In 2023, using the very Sex Discrimination Act put in place to protect women, men are able to intrude on women-only spaces, services, and protections in the name of protection against sex-based discrimination. This is causing detriment to women. Many progressives insist that there is no conflict of interest between sex and gender identity, and indeed they will insist that it is transphobic to even try to talk about that conflict of interest. The conflict of interest is what's at the very heart of the Tickle v. Giggle case. Of course, in Australia, there is both federal level law and state level law. A fair question would be which law is relevant to the Tickle v. Giggle case, and does it matter that Tickle and Giggle reside in different states? The short and easy answer to that is that the law that's relevant in this case is the federal level law, in particular the Sex Discrimination Act. Media reporting on Tickle v. Giggle has noted as an important moment the removal of the definitions of man and woman from the Sex Discrimination Act in 2013. The problem with this is that it leaves open then who a women-only service or a men-only service is intended to protect or include. Now, the Sex Discrimination Act also protects sexual orientation under the umbrella of sex discrimination, and no one sees that as a problem, creating a kind of conflict of interest between sexual orientation and sex. So perhaps it needs to be explained why also having added gender identity under the umbrella of sex discrimination does create a conflict. No one says that the adding of sexual orientation under the umbrella of sex discrimination undermines women's rights by conflating sexual orientation with sex. Why isn't it the same for gender identity? It makes sense for sexual orientation to be protected under the umbrella of sex discrimination. Consider two people, one a man and one a woman, both of whom are attracted to men. So a gay man and a straight woman. If the gay man is stigmatized for his attractions, but the straight woman is not, then the gay man is being treated differently and worse on the basis of his sex. He's being treated differently and worse compared to a woman who does the same thing. That is sex discrimination. If we were to understand gender identity to mean something like gender nonconformity or gender expression, then that same form of reasoning would be available. Consider a man who has a feminine gender expression, compare him to a woman who has a feminine gender expression. If he is treated differently to her for doing the same thing, that is a form of sex discrimination. But this is not quite the claim that Tickle is making. Tickle is not making a claim about gender nonconformity or atypical gender expression. Tickle appears to be making a claim about gender identity. Tickle claims that he has changed his legal sex, so that the sex now on his birth certificate reads female. His claim is that he is legally female, and so should be treated as any other legal female is treated, namely, he should have access to female-only services, spaces, and provisions. The Giggle app is one such service or virtual space, so Tickle's belief is that in virtue of his being legally female, he should have access to the Giggle app. Tickle then is claiming a form of sex discrimination because he is legally female, but he is being treated differently to other people who are legally female in virtue of being trans. So he claims the protected attribute of gender identity as being a grounds of discrimination and the reason or explanation for his exclusion from the Giggle app. Another way to put this is to say Tickle is claiming that he is a woman, but he is being treated differently to other women. So Sal's exclusion of Tickle from the Giggle app would be just like she had chosen any other woman and chosen to arbitrarily exclude that woman from the app, say on the basis of some other protected attribute like that woman's race or pregnancy status or disability status or anything else. Sal is saying that the Giggle app offers its service on the basis of biological sex. The legal question will be whether Sal is in fact allowed to offer a service on the basis of biological sex, or only at best on the basis of legal sex. And things might be even worse than that, because the courts might decide that even legal sex is too stringent of a standard, and in fact single-sex or previously single-sex services should be offered on the basis of gender, some kind of amalgamation of biological sex, legal sex, and or self-identified gender identity. The Sex Discrimination Act has its legitimacy because of a specific piece of international law. That is the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW. The wording in CEDAW makes it very clear that when it talks about women, it has biological females in mind. So that is likely to be helpful in establishing that the Sex Discrimination Act is about the protection of biological sex, not legal sex. One question some people might have is whether this is really a problem about the law or a problem about the application of the law, particularly at the state levels. Is it that in practice, sex and gender identity are routinely conflated? The answer is that it seems to be a combination of these two things. Removing the definitions of woman and man from the Sex Discrimination Act in 2013 is a matter of the law, and it would help to add clarity were those definitions reintroduced. The Attorney General's guidelines on sex and gender, released subsequent to the 2013 amendments, is very confusing. They say that sex and gender identity are distinct, but then they go on to say they can be used interchangeably. The law is meant to be clear and unambiguous so that people can apply it. This confusion has caused a lot of problems in how government departments are trying to apply the law. They've ended up proceeding as though gender identity takes priority over sex. For example, gathering data on gender identity rather than sex. Sex ends up being displaced for gender identity. Sport is another good example here. You simply cannot include people on the basis of gender identity without creating a conflict with sex. And yet, progressives insist there's no conflict of interest here. So what's the outcome that gender-critical people should be hoping for in Tickle v. Giggle? A great outcome would be recognition that the inclusion of gender identity in the Sex Discrimination Act back in 2013 was in fact constitutionally invalid, with the outcome of now removing gender identity from the Sex Discrimination Act. We can hope to see the reintroduction of man, woman, and biological sex into the Sex Discrimination Act with their ordinary meanings. And we can hope for the Attorney General's guidelines on sex and gender to be withdrawn. The work wouldn't end there for gender-critical people, because we then need to go to the state level and make sure that our Equal Opportunity Acts, which protect both sex and gender identity, are actually being applied in a way that recognizes sex and gender identity as distinct attributes rather than conflating them, and rather than giving priority to gender identity whenever both attributes are present. The problem at the state level is certainly one of application rather than a problem in the letter of the law, although there is a question to flag about exactly the nature of the protected attribute we should be using to refer to trans people. Gender identity has its problems. And women should not have to prove some detriment in order for sex to take priority over gender identity when both are present. Rather, the default assumption should be that services are offered on the basis of sex, not gender identity, so a trans woman would have to make the case for an exemption to sex-based exclusion, rather than women's services having to justify excluding on the basis of gender identity. Women-only services should have the right to exclude all males regardless of the further attributes those males might have. And this is fairer because a lot of women's services just don't have the money to constantly be getting legal advice about whether they do or don't have the right to exclude. If this case goes the way that gender critical people would like, what does that get us? In particular, does that get Australian women the right to exclude on the basis of biological sex from all women-only services, spaces, and provisions? Yes, the outcome that we want would reinstate the social contract, which was broken in 2013. A man who wants to be in a women-only space would have to justify why he should be allowed to be there. The case is going forward, and the judge has granted to Tickle cost capping, which means the maximum damages he can be directed to award to Sal if Sal wins is $50,000. If you want to donate to Sal's crowdfunder, you can go to the website gigglecrowdfund.com. There's also more information there about the history of the case and the constitutional challenge. To recap, Tickle v. Giggle is a case of gender identity v. sex. Tickle believes that because he is legally female, he should be included in all of the same services that any other legally female person is included in, and that he has been discriminated against in the case of the Giggle app on the basis of his gender identity. That is, he believes he is a woman, and yet he has been treated differently to other women because he is trans. Sal believes she has the right to offer a service on the basis of biological sex, not legal sex and not gender identity. Tickle v. Giggle will help to establish whether previously single-sex spaces, services, or provisions can continue to be offered on the basis of biological sex, or whether instead they must be offered to at least some biological males on the grounds that those biological males have a legal sex of female or have a gender identity of woman or female. Keep an eye on Sal's website for updates as to when the next court dates are.